and it's designed to be educational. So what happens with an executor is the executor is the person who carries out the testator's wishes as they are written in the will. It's not a creative position. It's not necessarily a position of power, but it's about carrying forward duties. So before we get into what an executor should know, Tom, do you want to talk about how somebody would go about choosing an executor?
Well, they should go about it very carefully. Serving as an executor is a very important role. You're basically winding up the financial aspects of someone's life. So you want to select someone who you have trust and confidence in, and that they will carry out the directions you provided to them in accordance with the law. You should take into account a number of ideas, theories, issues. You want to think about how old they are, whether they're the same age as the decedent, whether they're going to be physically and mentally able to carry out the executor functions. You want to think about where they actually reside. Are they close enough to your residence where they will be able to easily carry out the fiduciary functions? Or do they live all the way across the country or even outside of the country? A lot of people automatically, as a knee-jerk reaction, select their spouse. Well, occasionally your spouse may be grieving to the point where they're not in a good position to make business decisions or tax elections, and you may be better off selecting someone independent, whether it be a professional or another family member or business associate. So there are a number of things to take into account.
Tom, since this is a 101 lesson and you mentioned decedent, would you like to tell everybody what a decedent is?
The decedent is the person who drafted the will or was involved in the drafting of the will. It's their will, and it's the person who passed away. Sometimes they're referred to as the testator, the person who signed the will.
So in addition to what you indicated, of course, you talked about location being close enough to handle the affairs of the person. What do you think about past, let's say, experience in handling certain affairs, financial savvy, maybe legal savvy, and the trust in the person? Would you say that those are important?
Very important. And whoever is going to serve in the executor role, they need to know their strengths and their weaknesses, because not everyone is a jack of all trades and can handle everything that an executor may face in administering an estate. And you need to explain to the executor that they shouldn't be fearful to fill in the blanks with someone who has a level of expertise better than them. As an example, if there are legal issues that they will be facing, they should talk to a lawyer. If there are accounting or tax issues that they will be dealing with, they need to seek out the advice of someone who has experience in accounting and tax. If they're going to be managing and investing assets for any period of time, they should talk to a financial advisor who has some expertise in that area. The executor does not have to do everything themselves. That is not expected of them. They, as I said, they need to know their strengths and their weaknesses.
Thank you, Tom. Now, in my opinion, when someone's drafting a will or preparing to draft a will, they should talk with the person or people that they wish to choose as their executors in order to determine whether those people are even interested in serving or whether they consider themselves capable. So, of course, you're asking questions at a time that is more opportune. We don't know what circumstances will be down the road, but we can try and make sense of things. Do you think that it's important to let somebody know, one, that you want them to be the executor or executrix, and two, to let them know about what their duties will entail, as in what your assets will be? Or do you think it's more important to let them know where to find a list of your assets?
All of that is very important. It would, in a perfect situation, the executor should be involved to some degree, even in the planning process. But certainly the testator should meet with the person they want to serve in that role. One, ask them if they're willing to serve. And certainly it doesn't hurt to show them the will and to go over what the objectives are. So everyone is on the same page. There's nothing wrong with bringing in the executor and having the testator and the attorney who's drafting the estate planning documents to go over what's involved, what's expected, and to make sure everyone understands that everyone agrees as to what the objectives are.
So Tom, the other day we were discussing this and what we were going to be talking about. And one of the things that you had brought up was that Everybody Loves Raymond episode, wherein Deborah and Raymond invited the neighbors over to ask them if they would then be the guardians of their children. And they respectfully declined. They did not want to be the guardians of Deborah and Raymond's children. And that does in fact happen. Some people are simply not interested in the extra duties of these certain roles.
Absolutely. It's a tremendous responsibility to serve in any fiduciary capacity, and that includes an executor, a trustee, or a guardian of minor children, or someone who's incapacitated. All of those fiduciary roles, you're taking care of someone else or looking out and managing someone else's money. So there's a very large commitment from both a time and energy standpoint, and not everyone is cut out to serve in those capacities.
And certainly not only that, but also for the benefit of the final beneficiaries of the assets of the estate, you have the issue of whether or not this person is able to serve, whether they're willing to serve. If they're not ready to step up to the plate at that time, and we have to then go to successor executors, or we have to go through administration CTA to appoint someone else when the executor is not available to serve, it delays the conclusion of the probate, the conclusion of wrapping up the estate, the distribution of assets to beneficiaries who may be waiting for those assets.
Yes, and it could also lead to wasting of assets, or of course, when you have stock market volatility, if significant time passes before someone can actually manage those assets, you could lead to loss of income, loss of growth in assets. Particularly if there's a small family business involved, sometimes the sale of that business needs to happen fairly quickly. A perfect example is if you have like a dental practice, the dentist passes away. That practice has some value, but only for a relatively short period of time. 6 months or a year later, that dental practice has no value anymore.
Right. That's actually one of the seminars that I've done for the Chamber of Commerce, which is the planning in those cases, and it's critical, right? I mean, that's something that we'll actually cover on a different day, but it's absolutely critical. And I know your CPA, not necessarily a financial consultant, but you just said stock market volatility. Are we buy, sell, or hold with the upcoming election right now? So
Bye. No.
So with the duties of an executor, we're going to get into that in a minute. But what's interesting is that the testator names in the will the executor, but what happens is that person's not empowered to act until they're actually appointed, which is the process of probating the will. When you probate the will is when everything goes through and it's signed off on by me in this office, at which point now you're the executor. So after I appoint someone the executor, what would you say are some of the key responsibilities right off the bat?
Well, the general responsibilities of an executor, they need to collect all of the decedent's assets, find out all of the existing liabilities that the decedent had, file all final income tax returns on behalf of the decedent, and address any death tax returns that are required, which could be income tax returns on behalf of the estate, or an inheritance tax return, or if the estate is significant enough, a federal estate tax return. And that's just a general overview, but there are a number of things that the executor has to do as they initiate the administration process, including obtaining an employer identification number for the estate. That's similar to a social security number for an individual. They need to have all of the decedent's mail forwarded directly to the executor, which will be a great source to discover assets and liabilities. They need to issue what's known as a notice of probate, which is required to all next of kin and all beneficiaries of the estate, so that everyone knows who is the executor, what the will provides, so that you can initiate the ongoing communication between the executor and the beneficiaries, which is very important to keep everyone apprised as to how the process of administration is moving along.
Excellent. So the executor obviously takes on significant responsibility here. We talked a little bit earlier about bringing the executor to the table when you're preparing the will, what the testator should let them know, what they shouldn't let them know. Some people really want to keep that secret. They don't want fighting. They don't want, if one of the kids is going to be the executor, they don't necessarily want the other kids to know what's going to happen because they don't want issues there. So let's say the person chose not to bring the executor to the table when they were drafting, and the executor does not have a significant amount of information. Where would the executor go to find out what the person's assets would be? How would you go about something like that?
Well, they're at somewhat of a disadvantage, but it's very common for that to happen. You start at the home of the decedent, and hopefully there is some place within the home where there are financial records maintained, so that you can get the banking and brokerage information, maybe even a copy of the deed. If real estate is owned, you want to get back tax returns. They're a very great source of finding out what assets the decedent had, because if they have bank accounts generating interest, they will have interest income reflected on the tax returns. The same thing with dividend income. So you basically look through the home of the decedent, you gather the financial records that exist. And the key thing is, by getting the mail forwarded to you, that every creditor is going to ultimately mail an invoice if they're owed money. So that is how you're going to determine how much money is owed by the decedent. And hopefully any safe deposit box invoices, life insurance premium payment invoices, everything that you need to know, unless it's digital, should come through the mail and provide you with some good information over a period of time.
I'm glad you mentioned that, because the other day when we were setting this up, we talked about the digital age. So how does it work? Now, let's say somebody has a Swiss bank account, they're not getting statements, they're getting it digitally. Maybe they were going through something in their life, so they were a little bit secretive about what they had. Passwords on some accounts have to be updated every couple of months. What do you recommend that the executor do in a circumstance like that?
Well, hopefully the executor will learn of these accounts. If you really are that secretive, a lot of these accounts go on never discovered.
So in that event, you of course would tell the executor at some point in the future, you may want to check the unclaimed
property. Yes. Absolutely.
Things do end up there, and it's amazing the amounts, because everybody says that if you die without a will, everything goes to the state, but it actually goes to the state unclaimed property fund, where you can eventually one day, sometimes 20 years later, locate it, which is interesting. But again, it would depend on the account. If it's a Swiss account and it continues, if it's an out of country account, and it's then kept in a certain format where it will be allowed to continue, where there's enough money in it for the monthly fees, if there are any, to continue to be withdrawn by the bank, they may not send the same notices that we receive here in the States, and it may go completely undiscovered.
That is true. It happens all the time.
And I'm sure there are significant amounts that are out there.
They actually publish, I think twice a year in local newspapers, voluminous unclaimed property that exists and is being maintained by the state of New Jersey. But you can also, they have a website where you can go on and you can search by last name, you can search by address, and you can see whether any of your relatives or even you have any unclaimed property with the state of New Jersey.
And it's amazing how it happens. I actually years ago had put a deposit on a commercial property that never closed. And there was a discrepancy as to why it didn't close. And later the funds were given to unclaimed property. And somebody did notify me that they had read it in exactly that.
Right.
Yes, it was many years ago. So what about, and I know we talked about this the other day, when you have assets in a residence, let's say somebody has a house, and let's say it's full of belongings. And of course, kids, when somebody passes, a sentimental value attaches to items. They really have no monetary value. A used couch, a mixer, an old cap gun. These are all things that I've heard people talk about. They don't have a financial value per se. They may if they're antiques. We talked the other day about possibly having an appraiser come in. We talked about almost a lottery system whereby you offset monetary values. Is that something you frequently see?
Yes, and it's interesting how the tangible personal property that does not have significant monetary value sometimes becomes the primary asset of the estate that family members either argue about or fight about. And of course, independent third parties don't quite get the attraction, but of course, that's what it's all based upon sentimental value. But it is very common to have the family, the primary beneficiaries of the tangible personal property, appear at the house and go through a selection process. And if everyone agrees as to who gets what, it's very simple. Life doesn't always work that well. And if they can't agree because there are three people who want this particular item, you then have to develop a process which everyone agrees to so they can each get a fair or equitable share of the tangible personal property received.
How often do you see litigation over something that has sentimental value as opposed to something that has monetary value that can be divided?
Well, anytime there's litigation, that's always an aspect of it. That's the bottom line. And sometimes that becomes the issue which is the most difficult to resolve. And the sad fact is some of those items have a tendency to disappear early on after the decedent's passing, based solely upon who gets to the house first. And within the family, they know who has what. But there's no evidence of it, and it's difficult to prove to the court. Quite frankly, the judges hate that aspect of the litigation because it's very difficult to resolve. And that's why you hope in any type of mediation or in settlement discussions, the family members can come to some reasonable resolution of arguing over the items that have no value, no monetary value.
What I think is interesting is the aspect of life insurance and annuities, whereby they have a designated beneficiary and pass outside of the estate. So they're not actually part of the probate estate. But as a tax expert, you want to talk a little bit about how that plays in, how the tax aspect plays in, and also in the event that the state has debts, can they be attached for that purpose?
Yes. Estates typically pass one of three ways. Through probate, which is in accordance with the directions in the will, by contract, which includes the life insurance, the annuities, the 401ks, the IRAs, where there's a contract between the decedent and the institution maintaining those assets, and by operation of law. Jointly owned assets with right of survivorship, bank accounts, brokerage accounts, real estate owned jointly with right of survivorship, they pass to the surviving joint owner by operation of law. And it's very common for a significant portion of the estate to pass outside of probate. And even though assets pass outside of probate, that doesn't mean they're non-taxable. You have a probate estate and you have a taxable estate. And usually the taxable estate, or I would say probably always, the taxable estate is much larger than the probate estate. And it's a relatively common planning technique to provide that all the debts, expenses, and taxes be paid out of the residuary of the probate estate. And if you have significant assets passing outside of probate, The poor probate beneficiaries are paying the taxes and expenses that are on the assets that are passing outside of probate. And sometimes you even have a probate estate which is insufficient to pay all the taxes and expenses because such a significant value of the assets passed outside. But it needs to be taken into account in developing a plan. Who should be paying the fair share of taxes on whatever someone is inheriting?
Thank you. It's very informative. So Tom and I could talk all day about this because this is what we do, and we could probably delve into some significant details, but this is supposed to be a sort of 101 session, and it's designed to answer the questions of the viewers. So we're now going to turn it over to Christina to ask the questions that have been posted while we've been talking and see if any other questions come out of that.
Okay. So I have a number of questions that have come in. And the first one is there a conflict of interest when an executor is also a beneficiary? And the second part of that is, how does an executor make those beneficiaries comfortable with the arrangement?
There should not be a conflict of interest, but obviously there's a potential for a conflict of interest. However, the executor is a fiduciary, and the executor must administer the estate for the benefit of all the beneficiaries. The executor cannot take personal advantage of the fiduciary position to favor the executor against the other beneficiaries. And the way to avoid the conflict of interest is to have an ongoing open communication between the executor and the beneficiaries, letting the beneficiaries know what assets exist, what the inventory is, what the executor is doing on an ongoing basis. An estate administration can take anywhere from 6 months to 2 years, depending upon the complexities involved. And if you keep the beneficiaries fully informed as to what you're doing, you will alleviate any distrust, any concern, and the beneficiaries are likely to be happier because they understand what it is the executor is doing and what the executor is faced with in carrying out the estate administration.
Now, Tom, of course, at any time, the beneficiaries can ask for an informal accounting. They can actually pursue a formal accounting if they choose to do so. These things add expense to the administration, which decreases the assets that are available for final distribution to the beneficiaries. So, of course, not only the executor, if they're a beneficiary in this case, but the other beneficiaries would prefer to avoid that situation, which is why transparency is key throughout. But at some point in most estates, at least you will have an informal accounting that takes place. So the beneficiaries will see what the corpus of the estate consisted of, what was expended, what went to each of the beneficiaries. They'll have received and viewed a copy of the will. They'll know what the percentages should have been, and they should have a pretty good idea of where the assets went. But sometimes in families, especially with estranged children who are included in the will, they will be under the impression or the belief somehow that there's a certain amount of money, there were more accounts than there actually were. And that's when you'll typically end up with a challenge, and you'll find yourself in some sort of formal accounting situation before the court when they think there's a significant amount of money missing. And I find in my experience that a lot of this depends on how close the siblings are to each other as well as to the parents. Typically, when you have estranged or strained relationships is when you come up with challenges. When you have families that work well together, they can almost work it out, and oftentimes you'll have well-off siblings that are willing to give more of their share to the other siblings, I found.
The problem is there's probably more dysfunctional families than non-dysfunctional families.
Yes, it does happen.
Families are tough. Families
happen.
are tough. And of course, now with everyone not living nearby, everyone is separated and all around the world. There's typically one family member who is close to the decedent, and there may be other family members who only see them once or twice a year.
Especially when you have an adult caregiver,
Yes.
a child sibling that's an adult caregiver, that person, of course, tends to be the executor because they were around to know everything, and that's where you see these presumptions of unfair dealing
Yes.
start coming up.
Yes.
Chris?
Okay, the next question is regarding compensation. Do you have any thoughts on an executor being compensated? Or what are the rules around that?
I'm going to let Tom cover that. He did a great job when we were talking about it the other day.
An executor is entitled to compensation by statute, and everyone should recognize that the executor is going to earn every penny of their compensation. It is a very difficult task. By statute, the executor is entitled to a percentage of the estate. The first $200,000 value of the estate, the executor is entitled to 5%. The next $800,000 of the estate, the executor is entitled to 3.5%. And any estate that has assets in excess of $1 million, the statute provides for an executor to receive 2% of the value of the estate over $1 million. There's also a statute which allows an executor in special circumstances to apply to the court and receive, if appropriate, extra commissions based upon the complexities and any extraordinary services which the executor provides to the estate for the benefit of the beneficiaries.
Okay, thank you. Okay, here's the next question. Do pay on death of bank accounts pass to heirs without tax consequences?
Very few things pass without tax consequences. But the pay on death accounts do go to the designated beneficiary, but it is subject to tax. It's like a jointly owned bank account. It's just another way to title the account. But it is definitely subject to tax.
Tom, while we're talking about taxes, I'm going to interject with a question of my own. Do you want to tell everyone, when you're winding up an estate, is there a time frame with regard to the filing of taxes? Is there a difference between the state taxes, the federal taxes, estate taxes? How does that all work depending on, obviously, the size of the estate and the amount of assets? You want to inform potential
Yes,
executors?
the executor must be aware of a number of different taxes that may come into play based upon the size of the estate, the relationship of the beneficiaries to the decedent, the income earned by the decedent pre-death, as well as the income earned by the estate post-death. First of all, depending upon when or the year that the decedent passes away, if the decedent had sufficient income in that year of death, the executor must file final federal and state income tax returns on behalf of the decedent. That's the first tax the executor is faced with. In addition to that, in New Jersey, if the decedent left assets to a non-Class A beneficiary, which is everyone other than spouses, anyone along the stirpital line, which is up to the grandparents and beyond, or down to children and grandchildren and so forth. There is an inheritance tax for everyone who is not a Class A beneficiary. That tax is due 8 months from the date of death. If the estate is very substantial, over $11 million or so, there's a potential for a federal estate tax, which may have to be paid. And of course, as the estate is being administered, the assets within the estate are generating income, and therefore there are income tax returns, which is a form 1041. Individuals file 1040s, estates and trusts file a form 1041. So the executor has to be aware that they have to file income tax returns based upon the income earned by the estate. And of course, as we know, income tax returns are typically done on a calendar year basis, and a state actually has an election. They can elect to select a fiscal year end based upon any month of the year up until the month before the decedent had passed. So you can actually select a month end for an estate, one of the few entities where you can still do that. So there are a number of tax issues that an executor may be faced with.
And for that, you would likely want to hire experts. And one question, in addition to everything you just talked about, can you get an extension if you need to?
Extensions to file are always available. Extensions to pay are a little trickier. And if you don't pay on time, you definitely will be subject to interest charges and maybe subject to penalties. There are some peculiar rules where sometimes you can get an extension of time to pay, but you typically need to pay on time.
Chris?
Okay. Well, can the normal person handle the estate administration, or should you hire an attorney, an accountant, etc.? I found this group on the internet, New Jersey Executor and Probate Resource Center. Do you have any opinion on this group? Along with the beginning of that question.
So I don't have an opinion on any group that's out there. Google has a lot of information, but it's Google or whatever other search engine you're using, so use it with discretion. As far as can a normal person do it, what is a normal person? What is their experience level? What is the size of the estate? What is the complexity? How many beneficiaries are there? Is there fighting between the beneficiaries, among the beneficiaries? Certainly, all of these things come into play in making that decision. So one way you can probably avoid running afoul of anything, especially when there are multiple beneficiaries, is to employ, at least to some degree, experts that can help you with this. But again, if let's pretend that you're Tom and you're taking care of an estate for a family member. With his level of experience, certainly Tom would be capable of doing it himself. And as he sits here before us today, he looks to me to be a perfectly normal person. Now, if we stack him up against someone who has none of that experience and say, are they capable? I would say it would likely fall somewhere in between.
Yes, I think, as I said earlier, you need to know what your limitations are. And when you are stuck and you don't understand how to resolve an issue, seek the guidance of someone who can assist you. The biggest mistake fiduciaries make is when they try to save the estate money and don't go out and get assistance, because more often than not, they will make a mistake. That would be like me trying to fix a plumbing problem. I will cause more problems for the plumber who has to come in and fix the problem I just made worse.
Okay. If a bank account is set up with the right of survivorship, does that account need to go to probate?
No, that is not a probatable asset. It passes outside of probate.
Okay. And here's another one. If an executor hires an attorney or an accountant, does the executor pay out of pocket or does it come out of the estate?
If the executor employs experts on behalf of the administration probating the estate, then the estate pays for those experts. It does not come out of the executor's fee, and it does not come out of the executor's pocket.
And that is provided for not only typically in a will. The will typically grant the executor the right to retain accountants, lawyers, etc. And also, I believe it's in the statute that the executor has the right to retain the services of people to assist them.
Okay. I have a couple of questions that are very, very similar. I think it's really the same question. So is there a time limitation to settle an estate, or how long does an estate have to remain open?
It's interesting. So there's no period of time that it has to remain open. And what's required is essentially due diligence at all times. In the event of a challenge to an executor, when somebody feels that an estate's not moving quickly enough, or that an executor's not moving quickly enough, and they want to have them removed, the other beneficiaries want their money, they're pushing for removal. It's highly unlikely that unless the executor has committed some sort of fraudulent activity or something like that, that a judge will remove them, because going back to the prior question about a normal person doing this on their own, this is not something that's necessarily easy for everyone. They don't do it every day. They're doing their best. They have a job, they have kids, they have other things going on in their life. They're typically trying to find the will, find the assets, get appointed executor, do everything that they have to do, run around to the financial institutions, prove who they are, get the letters testamentary out. It's a tremendous task and it takes a lot of time. So you will find that most judges are very sympathetic to an executor that is doing their best and trying to move this forward. So as Tom said, it can take from months to years to complete an estate. There's no specific time. The tax rules are the most stringent with regard to when things have to be wound up. And Tom, you want to add anything to that?
Well, the statute indicates that the executor is supposed to complete their task on an expeditious basis. That is subject to interpretation, of course. And as long as you're making some progress and you're moving the estate administration along, you're going to accomplish your task within a reasonable period of time. If there is litigation or problem assets, you have to have a clean up oil spill somewhere. You can run into all kinds of potential problems. Obviously, the completion of the administration will take some additional time.
Okay, we have quite a few questions still coming in. So this one is, if there's a joint bank account, which you say can pass outside of probate, but the money is supposed to be included in the amount in the will, I guess, to benefit other beneficiaries. What happens? What happens if there's a joint bank account?
That's usually when you have a dispute.
Right.
Well, the thing is, if the money is jointly owned, it is not passing in accordance with the will. So we have a conflict already. And that is a very common conflict because when people establish joint accounts, a lot of them are not necessarily doing so with the anticipation that that money is going to go to the joint owner as an inheritance. They're doing it more for the convenience of the elderly person and the other joint owner, so they can each have access to the account and take care of things during the life of the decedent. But the bottom line is the law provides that the jointly owned account passes to the surviving joint owner. If the surviving joint owner agrees that that asset should pass in accordance with the terms of the will, of course, he or she can put it back into the estate or share it with the beneficiaries. But that is a very common area of estate litigation because significant accounts can be jointly owned with right of survivorship, but the family thinks that that should be included in the probate estate.
I think that was a really great question because there we go. It obviates how litigation takes place because we talked about the probate estate, but then the assets that are outside of probate. And of course, if you're a beneficiary that receives a certain amount under the will, but you're not listed as a designated beneficiary on one of these assets, the question is, well, why did they get it? This isn't fair to me. I deserve some of that. And then in spite of what the statute says as to how people want it to pass, this is when the fights ensue. And now there's an underlying bitterness that will move forward with the entire matter. So it makes it more likely that someone will litigate later. So one thing that, going back to our prior session, we talked about when you draft, sometimes you want to include the fact that if somebody is receiving something outside, you may want to equalize what they're receiving inside of the will. Maybe if you gave a lifetime transfer, you want to account for that lifetime transfer by mentioning it in the will. So it's very interesting what does and does not lead to litigation.
Yes. I believe the statute actually provides that if it's a jointly owned account, not a pay on death account, but a jointly owned account, that there is a presumption that the decedent meant for the surviving joint owner to receive the balance of the account upon death. That presumption can be rebutted, but it's not an easy presumption to rebut.
Okay. Just as an add-on to that, is it wise to make the executor a joint owner of a bank account? And if it's stated in the will,
I'm sorry, say that again? If it's,
is it wise to make the executor, your executor, a joint owner in your bank account?
sorry, I thought you said after about the will. So as far as making the executor a joint owner on the bank account, that goes back to the situation where you now have families spread out everywhere. You have an adult child that maybe mom or dad moved in with. There's a mother-daughter house situation. Bills are being paid out of that account. Mom or dad put their money into a certain bank account. The kid that they're living with is helping them, going and doing their grocery shopping, paying their bills, handling the affairs that they're not necessarily interested in handling or capable of handling, as the case may be, on a day-to-day basis. It's really not, it's a judgment call as to whether it's wise, because now the person that you're putting in charge of your finances is also the person that you've chosen as your executor, which means that it's somebody that you find trustworthy, reliable, that's probably somebody that's local to you. It could be a very good choice. Could it be a bad choice too? Certainly, in terms of, I keep going back to the litigation aspect in this regard, because now it comes out to sort of an inference that the other siblings could make, depending on their relationships, that there's some sort of undue influence, and it could lead to a will challenge if they see one child that they don't trust for one reason or another having too much control over mom or dad's affairs.
Yeah, and if I could add to that, whenever a joint account is created, as long as everyone involved understands why the joint account is being created and what happens upon the death of the joint owner, it's a fine tool to use in financial planning. The problem is, it is very common for an elderly person to put their caretaker's name on a joint account just for administrative convenience, not recognizing that that turns into an inheritance for the designated joint owner. So it shouldn't be as evil, oh, let's just add my oldest son, my oldest daughter, my caretaker as a joint owner. You're basically making a completed gift, even though it's not completed until death, but you're making a transfer that ultimately becomes a completed gift to the other joint owner. And that's not the reason why most people establish a joint account.
Okay. Are there liabilities associated with being an executor? Can you be sued?
Absolutely, you can be sued. And certainly a beneficiary can bring a challenge, which has to go to a certain level before it would move forward in the courts. But if someone can show perhaps fraudulent dealings, if money goes missing, if all of a sudden you commingled some of the funds of the estate into your own funds, if beneficiaries are being paid a certain amount without the agreement by all, that are being paid in advance. We talked about this the other day, Tom, where sometimes a payment can be made. We have a sizable estate and we know that the debts are approximately 200,000. We could potentially give the top 200,000 to the beneficiaries to tide some people over that might be going through difficult times in proportion to what's listed in the will, and we still have that significant cushion of 6,000 or $6 million or $600,000. I sound like I'm in a presidential debate right now. $600,000 that we can use to cover any debts that we don't know about that might arise. So that being said, if we find that maybe distributions are being made in unfair proportions, things like that, it could begin to lead to people making challenges, making inquiries, and trying to have somebody removed. And certainly there are times that the people that are acting as fiduciaries, be it an executor or administrator, certainly are dealing in an unfair manner with the assets of the estate. So sometimes the challenge is very legitimate. I personally, when I was practicing, handled an estate where somebody suddenly developed a gambling habit and there were no assets left, and this person had no assets to give. So in this particular case, the judge had not decided that bond would be required, decided that bond would not be required, and the assets were gone, but for a very minimal amount. And now the question is, what do you do? If you put this person in jail, does it bring the assets back? No, the person can't amass the assets. They had none in all their life. They had amassed none to begin with. So if you see something like that coming, certainly you want to bring a challenge earlier rather than later so that you can stop that, because once the assets have been disposed of, they are irrevocably gone in the event that bond isn't furnished.
In addition to that, an executor can be sued by one of the decedent's creditors if they don't properly handle the administration. As an example, if the executor makes a premature distribution before confirming what liabilities exist, the executor could be personally liable for making such a premature distribution. That's why you've got to take the time required to collect all assets and to learn and discover all existing liabilities. The executor has, that's one of the reasons why the executor gets a commission. The executor has a job to do, which typically takes time, and it takes time to discover what assets exist and what liabilities exist.
Okay,
And
well,
that's something, Christina, just to add one thing to that. Tom just really summed it up. Being an executor is really a job. It's a for-pay job, and you have to conduct yourself in the manner in which you would in a workplace, right? You want to make sure that you limit any issue for anyone that you deal with in that workplace, be it as an executor or anywhere else. So in that regard, if you act in an untoward fashion as an executor, you can be sued, you can be held personally liable, just as if you acted in a reckless fashion anywhere else in society.
and that was really one of the questions, and it gets to time. How much time does it take? And Surrogate, you explained that it really can be a job depending upon, I guess, the size of the estate. Would that be true?
The size and the complexity.
Mm-hmm. Okay. There's quite a few questions regarding the tax. So are items within an irrevocable trust subject to tax upon death?
Well, you really need to see the trust agreement. I mean, it depends upon when the irrevocable trust was established, what is in the irrevocable trust. If the irrevocable trust was established years ago and it was properly established, there was actually a gift made when the funding of the trust took place. So the assets within that irrevocable trust are no longer owned by the decedent and therefore not subject to a death tax because they made a completed gift at some point prior to death.
So let's talk about, I'm gonna ask you as the tax guy here. Now you have a trust, let's talk about a special needs trust that's funded by an insurance policy and how that would pass with taxes, because that's something that,
Well, special needs trust is a very specialized trust. And it depends, first of all, on who is funding the trust. You said life insurance.
let's say a parent passed, they had life insurance, they're funding the trust.
Okay, life insurance to a specifically named beneficiary is not subject to the New Jersey inheritance tax. If it's payable to the estate, it is subject to New Jersey inheritance tax. So if the beneficiary designation was properly done and it goes directly to a trust, it should not be subject to the inheritance tax. Now, if you have a really large estate and you're now in the federal tax realm, it would be subject to the federal estate tax.
Is there a statute of limitations to file against an executor?
It depends upon what you're filing against them for, but the answer is yes. The problem is you can have a claim, number of different claims against an executor. The question is what, and I don't know whether you're able to find that out.
Yeah.
If you're challenging a will, you're supposed to do it within a relatively short period of time. The statute does provide exceptions and allows the court to expand that time. But if you're challenging the will, you want to do something as soon as possible, you actually, there's a procedure where you can file what is known as a caveat against the probate of the will, and that's a very useful tool if you're contemplating litigation. You can actually file a notice with the surrogate to not accept a will for probate because you are actually going to challenge it. And the caveat should be filed before the person probates the will and is qualified as an executor, because the caveat prevents that from happening. And it moves the whole proceeding into the superior court probate part to have litigation over the probate of the will. If you're suing an executor for malfeasance because they did something inappropriate, it would depend upon the nature of your claim as to what the statute of limitations is.
And also your standing. If you're a creditor that didn't speak up in a certain amount of time, you can't suddenly bring a challenge later against an executor for not honoring a claim that they didn't know existed, that they couldn't have had reasonable notice that existed. Typically, like you said, if it's a credit card company or something, if it's a typical creditor, you're gonna get something in the mail on a regular basis. But you may have something such as, let's say somebody held a mortgage that had balloon payments and it wasn't to come due until a certain time. Payments were irregular and they didn't have reason to know that the person passed because they weren't a family member. It was somebody distant. In that case, certainly it would be a questionable standard, because would you have had reason to know that you needed to file a claim? And would the executor have had reason to know that a claim could have existed? Which goes back to the due diligence.
This one is regarding expenses. So how are funeral expenses paid, and is there a priority of expenses that the executor needs to follow?
Typically, funeral expenses are paid off the top. They're paid out of the estate. Some people do have insurance policies to pay them, but one of the first things that you have to make sure that you do is pay the funeral, because the body needs to be taken care of. Anything you want to add?
Yes, funeral expenses are the top priority in the pecking order of liabilities and expenses to be paid by the estate. Administration expenses fall right under funeral expenses. Taxes are below the administration expenses.
Okay, how does an estate become finalized?
Typically, how you would finalize an estate is by the final distribution to the beneficiaries, with the completion of what's called release and refunding bonds, wherein some sort of acceptance has been made by the beneficiaries of the amount that they're receiving. So it's a formal form that they're signing off on, saying, I'm aware of what was in the estate. This is the amount that I'm receiving. I'm aware that this is the amount that I'm receiving. And I believe that this is the fair amount based on my understanding of the estate, the assets of the estate, and the debts. And then that also depends on whether they've required an accounting, whether they've seen an accounting, whether it was informal or formal. But at the bottom line is, upon approval and distribution to the beneficiaries, which again cannot be done until certain requirements are met, which is the payment to certain creditors, which would include the taxes. The final distribution cannot be made. The debts have been covered and the taxes have been paid.
Yes, and that release and refunding bond should be filed with the surrogate's court, and that puts the surrogate's court on notice that the administration has come to a conclusion. And I would be remiss if I didn't bring one other executor requirement in concluding an administration of the estate is they actually have to do what is known as a child support search prior to making a distribution to a beneficiary. Quite frankly, if a beneficiary owes child support, and you don't do the search and pay and you make the distribution, the executor could be personally liable for the outstanding child support. So that's standard procedure in bringing an administration of an estate to a conclusion and making any distribution from the estate. The first thing you do is get a release and a refunding bond. The second thing you do is you perform a child support search. And that's before you make a distribution.
Okay. All right, we're coming up on an hour, so I have one more question we can take, and then I'm going to turn it back to the surrogate for the close. So this goes back to the funeral expenses. The estate hasn't been probated yet, but you have to pay the funeral expenses. Are you supposed to personally, does the executor personally pay for that and they get reimbursed, or does the funeral home wait? The question is, who pays for mom's funeral, basically?
Typically, someone from the family will pay if the executor does not yet have enough assets accrued or accumulated that they've been able to find in the estate. As you know, most people are very, very quickly after their passing, and there's not always time for people to get things together. It really depends. And I was here a very short time when we had a woman pass that didn't have adequate assets in her estate to pay. There was a reverse mortgage on the home. She didn't have anything, and they were trying to find relatives to pay. The funeral home was willing to work with them, but the funeral home does want to receive their payment because they are performing that service, and it costs them money simply to perform what they have to perform, as well as then they have to open a grave or do the cremation. They're out of pocket, so they are looking for that. So whether it's the relatives that pay or the executor that pays, there's that presumption that they will then be reimbursed. But if there are not assets in the estate, it does not always happen. Tom, you want to add anything?
Yeah, you must keep in mind that the executor, it can't be appointed by law until 10 days after the date of death of the decedent. And one of the documents you need in order to qualify as executor is a death certificate, which is typically obtained through the funeral and burial process. And it usually takes a few days to get your death certificate. So it's just a function of life and timing that the burial and the funeral services take place prior to the qualification of the executor. There are a few funeral homes which will work with the family and wait for payment. Most, quite frankly, will not. They're providing a very significant service. And quite frankly, there's a lot of expenses that need to be paid along with the funeral services. Everything from the purchase of the casket, the opening of a grave at the cemetery, all of things cost money. And most funeral homes are not going to lay out that money on the family's behalf.
Okay.
But the bottom line is the estate's first liability is to pay for the funeral expenses. So whoever pays them up front, they're in effect loaning the estate the amount of money necessary to have the decedent buried.
Okay, thank you. And surrogate, I'm going to turn it over to you for the close. We're right on 1 o'clock.
Thank you, everyone. I hope that this has been informative. We appreciate your joining us. We will be having another session next month. We'll be releasing the information shortly on that. If you have any questions about today's seminar, you'll find it on our website, which is marissurrogate.com. If you have any specific questions, we can't give specific advice. We can give specific answers to general questions. You can send them to surrogate@co.maris.nj.us, and we'll be happy to answer those. Tom, I want to thank you for being here today.
My pleasure.
Wealth of knowledge. And Christina, I want to thank you for putting this together and being our host today.
You're welcome.
Thank you.
Thank you, everyone, for participating. Have a great day.